Good afternoon, everybody. This is Matt Cruz and Per Oscarsson, Sarah Smith. We are the principal members of the estate group at Beresford Booth. And we'd like to discuss dispute resolution within the context of estate administration today. I think we've got a few points that are applicable not only to disputes and resolving disputes in the context of an estate administration, but some of the litigation and settlement points that we'll be discussing will help or be informative about other forms of legal disputes as well. When we talk, just as a quick reminder, when we talk about the process of estate administration, we're not just talking about probate. The process of administration needs to accomplish the same 5 steps or proceed in the same 5 stages, whether probate is required or not. Probate is just one method or one process that may be required as a part of the administrative process. So really today, we're talking about resolving disputes that could arise at any level of the 5 stages of estate administration. Quick reminder, we've talked about these before, but as a quick reminder, the 5 stages of administration are as follows. First, you have to determine who's in charge. In a probate matter, it would be either a nominee by a will, or if no will, a petitioner under a statute to be appointed, or if a trust, the person in charge would be the successor trustee nominated in the trust. First, you have to figure out who's in charge. You can imagine there can be disputes right off the bat as to who's in charge. Secondly, the person in charge is responsible for gathering and controlling all the assets of the decedent. Not hard to imagine disputes could arise in that context. Thirdly, we've got to pay the bills. There can be disputes with creditors over the amounts or appropriateness of a bill. Not hard to imagine disputes coming there. Fourthly, after the bills are paid and all the assets have been gathered, then we get to the distribution phase of the administration process. And finally, then we close the estate. At the distribution phase, that's when the disputes amongst the heirs typically arise. Although they can arise in prior stages of the administration process, we see most of the disputes amongst the heirs of an estate at this 4th distribution stage. And then you say, well, what kind of disputes arise at the closing phase? Well, typically it's part of the closing and distribution combined phases where there has to be a final accounting, and the heirs, beneficiaries of an estate, need to approve the expenses incurred by the administrator, need to be happy with them. This is where in the closing process, we tend to see most accounting type disputes. Anyway, those 5 stages: who's in charge, gather the assets, pay the bills, distribute, close the estate. At any level, disputes can arise. And because each of those levels require different responsibilities, there some methods of resolving disputes differ at any of those stages. Though there are some fundamentals, we're not really intending to get too far into the weeds here. Instead, Per, Sarah, and I today would like to discuss some basic fundamental issues so that you can be familiar with the dispute resolution process and some of the things that you'll be speaking with your lawyer about should you find yourself in some form of estate dispute. There are 2 basic paths or avenues. There's a settlement path and a litigation path. Both paths can be used to resolve an estate dispute. And often in the course of a dispute, your lawyer will want to maintain perspective on both paths at the same time. Rarely will you go to a lawyer and say, I only want to go to trial on this matter, without regard to any possibility of settling. Per's going to talk to you a little bit about some fundamental principles in the context of settling an estate dispute. Sarah is going to walk us through some of the fundamental considerations under our Tedra statute. The Tedra statute, we're really fortunate to have the Tedra statute because it does put a lot of tools in a lawyer's tool bag to help solve an estate dispute, even if that dispute is submitted to litigation. So Sarah will talk about some of those fundamentals, and then I'll finish by discussing some fundamental litigation principles that you should be looking to discuss with your attorney throughout any form of estate dispute as that progresses. And then we'll try to end up with some questions. So with that, pair, what do you think, and what should we all have in mind as we unfortunately find ourselves in the midst, or clients find ourselves in the midst of estate disputes? In terms of the settlement avenue, what opportunities are there to settle? What are the fundamental things we should be keeping in mind if an estate dispute is going to be settled?
Well, I think there are a couple of things. First, you could have any level of dispute, from a very minor one, which may be as simple as just a phone call between the parties to resolve, or it could be a very significant dispute that maybe at first blush may look like it's really headed for litigation no matter what. But even that kind of a dispute is a possibility of a settlement agreement. Now, that settlement agreement, of course, it could be between the parties, whether it be a personal representative and a creditor, personal representative and an heir or beneficiary. And so you really have to look at each situation separately. If you're going to try for any kind of a settlement, whether it be just by agreement or a mediation where you've got a professional mediator assisting the parties in trying to reach a settlement, one of the things you want to be looking at is the parties need to be very transparent with each other, because you can't really get a good, decent settlement if someone's hiding the ball. And if you are transparent with the other side, there is a much better chance of developing trust. If there wasn't trust there before, the transparency will help develop trust. It may help eliminate some distrust that might have been existing before all of this arose. Another thing is that the parties have to be willing to compromise. If someone's thinking, and I know people who will go into a negotiation of some sort with, this is my position, that's where I'm staying, and I'm not moving, the chances are not very good of the parties being able to reach a settlement. So both parties, or multiple parties, if multiple parties are involved, all have to be willing to compromise, because it will probably be necessary that someone's going to have to give up something, and maybe everybody has to give up something. The value of that something may be significantly different for each party to the settlement. And there's a great deal of value in being able to reach settlement. The two primary areas that I think of are the finality of a settlement and the certainty. And the finality, sure, if you go the litigation route, you will eventually have finality. But when is that going to happen? It may not happen as a result of trial, because appeals are possible, and all of that is a lengthy process. With settlement, with any luck at all, the parties don't spend an awful long time trying to reach an agreement. When they reach an agreement, they document the agreement and they perform the agreement. Now, dispute's done. You're not sitting there figuring, okay, I've got X number of months or years for this litigation process to play out and get all the discovery and all of that thing that has to be done. But you've got the finality now that, yeah, it's going to cost something to do financially, probably. There may be attorneys involved, so there will be attorney fee time. There may be part of the settlement may be a cost that one party has to pay to the other. And if you've reached that point where you have the agreement and you perform the agreement, all the dispute is gone. You don't have all of that flailing around that you could otherwise see. You also have the certainty, which you don't have if you end up going into an arbitration or trial, because although you may have some influence in what happens, you're not the ultimate decision maker in that case. In the arbitration, you've got an arbitrator making a decision which may or may not favor you. In a trial, typically you would have a judge making a decision. Hopefully you've been able to influence the judge to see your position and that your position is the appropriate one, and the judge rules in your favor. But you don't know that. And as we'll probably talk about a little bit later with Tedra, attorney's fees are possible, and the judge in a Tedra matter has quite a bit of flexibility in who gets assessed the attorney's fees. And you don't know that going in, and you don't know that until you've seen the ruling. And so there's uncertainty about, okay, what am I going to be required to do as a result of this ruling? And then how much am I going to have to pay? Or am I going to be benefited that I'm going to have all my attorney's fees paid by somebody else? And so I don't have that certainty in the arbitration or the trial setting that if the parties agree, one party will pay the other party's attorney's fees, they agree on it, they document it, or each party pays their own fees and costs. But at least you've got that, you've got an agreement, and now you can go on with the rest of life, or go on with the rest of the estate or trust administration.
Yeah. Hey, Per, remind us, if you would, when I meet with folks, there's often a lot of confusion between what mediation is versus what arbitration is. Can you distinguish those two for us?
Sure.
And maybe talk a little bit about, just very broadly and generally, the mediation process.
Sure. Well, the mediation process is you've got a mediator, usually trained in mediation, but their role is not to make a decision. The role is to try and they may tell each party the strengths and weaknesses of their own case, and they may work, and hopefully they're working to try to get the parties to get closer in their positions. But it's the parties who make the decision. The mediator's there just to facilitate getting to that decision.
How is the mediator? Yeah, how is the mediator selected, and how is the mediator paid generally?
Well, usually the parties select the mediator. Even if you go to a professional organization, usually of like retired judges and maybe even retired attorneys, there are several. JAMS and JDR are two alternate dispute resolution entities that have former judges, former court commissioners, and you can select a mediator from there. There are private attorneys who serve as mediators and advertise their services as mediators. Hopefully the parties can agree on the mediator. Typically, I have seen that the mediator has a provision that each side pays half of the fee for the mediation, including anything beyond the initial time. For example, they may allot 8 hours of time to the mediation. Sometimes, unfortunately, mediation can't get done in 8 hours. It may take 12 or more, and those may be 12 consecutive hours. So it can be a long day.
Yeah.
But the parties
I'm sorry to interrupt, Per. In terms of who pays for the mediation, generally it sounds like people go into mediation agreeing to each pay half of the mediator's fee or contribute toward the mediator's fee. Right. They're also, of course, paying their own lawyer typically to be there and guide in the mediation itself. So it can be expensive.
Yes.
Is payment of the fee, the mediator's fee, subject to negotiation, one of those things that could be agreed upon and negotiated in the mediation itself?
I think it could be. I haven't seen that happen, but I think it could be, because it is up to the parties there. They're the ones making the agreement. If they're using a mediator who has a fee schedule, at least as far as the mediator is concerned, each party is going to be paying half. But I don't see that there'll be anything that would prevent the parties from agreeing that one party may pay more or may pay all of the mediation fees. Mm-hmm. But that, again, that's going to be subject to an agreement between the parties.
What about the process of mediation? So we get to mediation. What have we done to get there in advance of the day of mediation? And then what's your experience about how the mediation is typically conducted for the parties? Are they all in the same room, or are they in separate rooms, or how does that typically occur?
Well, hopefully you've done a lot of homework. So you know the facts and you know the law that's going to support the position, but you're also going to know the facts and the law that may not support your position. And you have to be ready to deal with that. Typically, there'll be a mediation brief, sometimes in the form of a letter, that identifies for the mediator what the facts are, and maybe not in what I call excruciating detail, because that could go on for how many pages, who knows. But also it provides them with some of the legal authority that you're relying on for your position. Once you get to the mediation, typically you would not be in the same room with the other side. Pre-COVID, what you would see would be they'd be in the same building in different rooms, and the mediator would be shuttling back and forth between the two rooms. Now with COVID, I've been involved in a couple of mediations where all the parties have been in different cities, and the mediator has been in a different city, and technologically we are in different rooms in like a Zoom meeting, and the mediator is shuttling back and forth between the rooms electronically. And that has, my experience has been that has worked quite well. I think in both cases we had a very good mediator who could handle the technology and handled the actual mediation itself quite well that way.
Hey, Per, let me ask you, why not just put everybody in a room? You know, I think a lot of disputes are best resolved nose to nose. It's more efficient. You kind of get down to the issues right away. Why is there a benefit to be in separate rooms or electronically segregated? Why not just have everybody in the same room? Do you have any thoughts about that?
Well, it seems to me that well, I don't think the mediator may not be able to do the job as well when they're just sitting there mediating within the same room. And I think it also makes it more difficult for the parties each to talk with their own attorneys, because the attorney-client privilege is still going to apply. And if one party needs to talk with their attorney, somebody's going to have to leave the room and go somewhere else and talk, whether it's in a hallway, which is probably not the best alternative, or another room, which is probably the best. And so I think it also, depending upon the circumstances that led up to the dispute, it seems to me if there's a lot of animosity already built up and everybody's in the same room, it may be difficult to keep that in check. Whereas if they're in different rooms, at least while there's communication with the mediator, and in that case, there's no communication directly between the parties, it's all done through the mediator, then I think some of that animosity probably goes away, at least as far as the other party hearing it. The mediator may hear some of that, and by what they're being told and how they're being told things by a party. So they may get a flavor for the animosity that exists, but I don't think that the opportunity for that animosity to kind of spill over into the room is there when the mediator can be shuttling back and forth between two of the rooms, whether electronically or in person.
Yeah. So an estate dispute has arisen, and informal methods of settlement have failed, meaning the parties themselves were unable to resolve the dispute, either before or after they've hired counsel. Counsel for the parties have been unable to reach resolution. So we turn to formal settlement methods, principally involving mediation, where mediators appointed. The parties educate the mediator, and the mediation day comes. There's value in not being in the same room in terms of preserving the opportunity to have private and confidential communications with your lawyer as the mediation discussions continue. And then there's also the value of not inflaming or allowing emotions to get the best of the parties by segregating them. Usually these disputes wouldn't be disputes. I don't typically mediate disputes that are, unless they're hotly contested issues. If there's not a lot of emotion or strong feeling about an issue, normally we can get those kinds of issues resolved informally between the parties or with their lawyers. But we haven't been able to do that, so professional mediation is available. And it's normally, my experience is normally conducted just as Paris described it. And the point of mediation, unlike arbitration or trial, is not to get a decision, right? It's the mediator's job really is to work with both parties to see if they can compromise sufficiently to reach an agreement on the disputed issue. And then, as Per indicated, that agreement is usually memorialized in writing. So we've got written expression of what the parties have agreed to. And then that written expression is used to enforce the parties' agreement if there is confusion or uncertainty later. So, Sarah, we've gotten through the mediation process, and unfortunately it failed. Likely before the mediation has occurred, somebody has filed a lawsuit and likely, but not necessarily, invoked our trust and estate dispute resolution statute. Trust and estate dispute resolution is, there's an acronym, we refer to that as Tedra. We have a specific set of statutes that help parties resolve their disputes or litigate their disputes if that's necessary. What are some of the fundamentals about commencing a Tedra action if settlement hasn't, before it becomes necessary to file a lawsuit, been successful? So you reach the point where you have to file a lawsuit. What are some of the fundamental considerations as you're filing a Tedra action?
So generally speaking, the Tedra action, as you said, it's the Trust and Estate Disputes Resolution Act. It's going to cover all matters concerning estates and the assets of incapacitated, missing, or deceased persons. This includes non-probate assets, powers of attorney, and of course, as the name implies, all trust and trust matters. So this might be, going back to those 5 steps, determining classes of heirs and beneficiaries, or it might be directing a personal representative to take a specific action or not take a specific action, or even amending provisions of a will or a trust. The process begins by filing a petition with the court and serving notice to allow the parties to be aware that this process has begun, which the notice must be personally served or mailed to all the parties. And this must be served at least 20 days before the hearing on the petition, unless otherwise provided by the court of the statute. This is why you may, when talking to your attorney or in the process, hear this called a 21-day hearing. Might happen after, won't happen sooner. So generally, this first hearing, this 21-day hearing, the goal is to essentially have the hearing on the merits to resolve all the issues of fact and all of the issues of law. The goal is to give the court the opportunity to resolve the matter immediately on that first hearing. However, at or before that initial hearing, party might file notice of mediation, arbitration, such as we were just discussing, or request an opportunity to conduct discovery or request a trial date, rather than have the court resolve the matter at that first hearing. It's worth noting that Tedra proceedings are special proceedings under the civil rules of court, and they don't always operate under the same rules. For example, in a civil matter, you don't have to ask permission to engage in discovery. It's just automatically granted by merit of the lawsuit. But under a Tedra proceeding, you must seek permission from the court first. Additionally, you can ask, but the court can refuse. And they may choose to make a decision based on the merits, resolve all the issues of fact and law at that initial hearing. Tedra enables the court to do this, to decide matters promptly and officially at this initial hearing. And while giving them broad discretion and flexibility to establish an appropriate procedure to be followed. So if you've requested for mediation or arbitration, if the court doesn't decide the matter at that initial hearing, it may allow for mediation or arbitration, may allow for may decide other issues as the court deems proper, determine scope of discovery, even set a schedule for further proceedings. And it really depends on the situation, what strategy is going to work best, which I believe you have some thoughts to share on that.
Yeah, well, before we do that, Parent Sarah, let me ask a question that might be helpful to the audience. Let's assume that some form of dispute has arisen. The Tedra petition has been filed. Some litigation has ensued. Efforts at settling the matter, either the whole administration or the disputed issues, have failed. And the litigation continues, trial approaches, and the parties decide to have further discussions about settlement, and they strike an agreement. And let's say that their agreement, the terms of that agreement, are somewhat different than what the will would provide or what the trust at issue might provide. Is it possible that an agreement could be made that is inconsistent with the decedent's will or trust? And does the Tedra statute allow for that? Any of you have any thoughts on that?
Yeah, it is possible. Hopefully whatever agreement is reached is, you can show that there is a relationship between the agreement reached and the intent of the deceased or the trustor, because in a dispute, particularly when there's a dispute about the will of some sort, the court is looking for what was the testator's intent, because sometimes that, unfortunately, is not clear from the document, but there may be some hints there, and so the court is still going to be looking for that intent. But if the intent can't be determined, it seems to me there's a better chance for an agreement that may be inconsistent with the will, but maybe generally consistent with what would be expected to be the testator's intent. They could still reach an agreement, and the Tedra statute specifically allows for the parties to a dispute to reach an agreement. It also provides that either the agreement itself can be filed with the court, or a memorandum of the agreement can be filed with the court. And sometimes the parties may not want all of the details of the agreement to be a matter of public record, because they would become public record. Whereas a memorandum would provide a significant amount of detail, but not some of the details that might expose some financial information to the public, or maybe some information that the agreement includes that could be embarrassing to a party, that it may be necessary for the agreement, but certainly not necessary to include in a public record that anyone could go request, any member of the public could go request. So it's possible to have that agreement and have it have the force of law, because when the agreement or the memorandum is filed with the court, it has the effect of an order.
Yeah. Well, it sounds like Tedra is a pretty powerful tool in helping us resolve, either on a litigated or perhaps a negotiated basis, estate disputes. Sarah, am I correct in recalling that the Tedra statute applies to just all matters in connection with a person's either inter vivos or testamentary estate, any dispute or issue that might come up?
Right.
It has pretty broad application.
It has very broad applications, and actually building on Pear's point, it can also be used where provisions are missing from wills or trusts, these sorts of gifting procedures. It's a really great broad tool to help make things move more smoothly, and to make things essentially to be more efficient than requiring a larger formal trial when permissible.
Yeah. Well, I agree. We're fortunate to have the Tedra statute in Washington to use to help us resolve estate disputes. It is a very powerful tool, whether you're litigating or trying to settle a matter. So thank you both. I'd like to discuss just a couple of ideas concerning litigation in particular as a means of resolving estate disputes. These are just general observations. They really apply to any kind of litigation, but because costs can get out of hand, lawyers are expensive and the process can be expensive. There are a few things I think that everybody, when thinking about how to resolve a dispute that you're involved in, especially an estate dispute, you need to keep these things in mind. First of all, you're not required to have a lawyer, but if you feel the need for a lawyer, and these rules and procedures can be highly technical, I would encourage you, as the very first point that you need to think about and resolve, is the need for seasoned, experienced counsel. Don't go to a personal injury lawyer to help you resolve an estate dispute under Tedra or otherwise if that lawyer is not also well experienced in estate matters. For obvious reasons, our knowledge and experience lead to the judgment that you're really buying when you hire a lawyer to represent your position. That judgment and advice the lawyer gives needs to be the product of direct experience in estate matters and estate disputes if you're going to be well represented. Good general rule. Certainly there are some exceptions. Look for, however, a seasoned, experienced estate lawyer if you're trying to work your way through an estate-related dispute.
Matt, if I could kind of add to that, I would suggest that someone who's facing that try to get the lawyer involved earlier in the process than later, because although they could get involved later, if the parties have taken actions that may not be in the best interest of one side or the other, maybe those can be undone if necessary. But if the advice was provided before they took that action might not have been taken, and it may not be necessary to try and unwind something or quote unquote fix it. So getting someone involved early, I think, can be very beneficial.
Yeah, good point. Additionally, you're likely, by engaging seasoned, experienced estate counsel to help you resolve the dispute, you're likely to get a better fundamental case analysis. That kind of a lawyer is going to know the law, going to know much of the case law, in addition to the statutory law. They're going to talk to you about the circumstances surrounding the dispute, or the way we look at it, gather the facts about what's gone on that led to the dispute. And they're going to be able to apply the relevant law to your factual situation in order to come up with a good fundamental analysis about the strengths and weaknesses of your case in a way that either an inexperienced or inexperienced in this area of law type of a lawyer just won't be able to come up with for you. So you've got to get the analysis correct, is my point. And you have much better chance, be much better served if you're engaging an experienced estate lawyer. Now, I would also encourage you, because of the possibility that you'd have to litigate the resolution of this dispute, that you consider engaging somebody that's got fairly significant litigation experience. Lawyers tend to either be non-litigators, litigators, and many of us have experience on both sides of things. If there's a chance that you'll have to litigate to resolution of the dispute, you really should factor that into who you hire up front. The litigating attorney has been through all the pre-litigation process leading up to trial. So one good way to select appropriate counsel is to look into their litigation experience. And one good way to figure that out is to look into their trial experience. Trial lawyers with significant trial experience will have been through the pretrial process a number of times. By far and away, more of these estate disputes are settled than tried. But an experienced trial lawyer will have gone through many more matters than just his or her trial experience would suggest in resolving things before trial. That's the kind of experience and seasoning that you want to look for when you're considering hiring a lawyer. So you get good, I should say, you get better upfront case analysis. And with better upfront case analysis, you have more information to make the strategic decisions that you'll have to make as you proceed either to settle or litigate to resolution your dispute. Additionally, seasoned counsel will be able to provide you with another important perspective. I refer to this as cost-benefit analysis. Having a practical view about what the litigation costs are and what your reward or award might be at the end of the process, and how much it will cost to get through the process, it is crucial. Nobody wants a judgment for $100,000 that's not collectible, or that only a fraction of the award is collectible. That's just an impractical basis. If your lawyer is not talking to you about the relevant law, developing the factual evidence in your situation, and talking to you about cost-benefit issues throughout the process, your lawyer is not doing you a good service, regardless of the significance of the dispute. You not only have to understand the risks of loss or strengths and weaknesses of your position, but you're entitled and should be demanding guidance on a cost-benefit basis as well, so you can make decisions about how to spend the money on your counsel as you proceed through the resolution process. Now, finally, let me say a word about attorney's fees, because attorney's fees in the American jurisprudence system have become a huge point of leverage. And I'm not going to be able to discuss all of the attorney fee nuance. However, I speak with people over and over again who come to see us either to settle or litigate a case. And particularly, though, when there's a dispute and we need to try to resolve that dispute, especially when it's litigated, the misperception is the winner of the dispute will get their attorney's fees. So if you win, if your side wins, the judge, because you've won, will reimburse you, make the losing party pay your fees, and you'll be brought back up to net zero. And so we're here to dispel you of that myth. So let me give you just a couple of general thoughts. First of all, when it comes to attorney fee analysis, the general rule in the United States is that you are not entitled to an award of attorney's fees unless there's a contractual or statutory or equitable basis for an award of fees. So if the nature of your dispute concerns an agreement of some kind, and that agreement fails to have a provision awarding a prevailing party in the event of a dispute their reasonable attorney's fees, you may not have basis to recover attorney's fees, meaning you'll go into the dispute knowing that you'll likely have to pay your own lawyer. If there's no statutory basis that governs the area of the dispute for an award of attorney's fees, again, you'll likely have to pay your own fees regardless of whether you prevail or not in the underlying dispute. Now, even where there may be a legal basis under a contract or a statute or otherwise as a foundation for an award of fees to the prevailing party, the other point that you need to understand, the way our system works, is whether an award of fees with or without bases, legal bases, is always a matter of judicial discretion. So in other words, you could have a contractual or statutory basis for an award of fees. You could prevail in the underlying dispute. The judge could say you win and still say, by exercise of discretion, you're not awarded your attorney's fees. It's possible. It's possible also that the judge, even in awarding attorney's fees, could exercise discretion to award only a portion of your fees. A judge might award a mere portion of the fees to the extent they find the fees you've incurred are unreasonable. Or just in the exercise of judicial discretion without factual finding, the judge could just decide to discount your fees by some percentage. We have litigated many cases where prevailing parties have not been awarded their fees, or their fees have been deemed unreasonably high, or for reasons that we never know, the judge has decided the fee request should be reduced. Of course, the judge's decision is always subject to appeal, but appealing a trial court's decision on fees is a very difficult task. There are certain circumstances where it's warranted, of course, but my point is, if you think when you win your justified position in any dispute, the win will be magnified by an award of your fees on an automatic basis, I'm here to tell you it doesn't work that way. The judge, regardless of legal foundation for an award of fees, even when you prevail, can always exercise discretion to deny fees or to reduce the fees that you're awarded. This becomes a great point of leverage in how you choose to decide to resolve a legal dispute. We have been involved in litigation over estate matters where fees have exceeded 6 figures and drawn into the 7 figures, more than $1 million in fees. That's the exception rather than the rule. And of course, the magnitude of the estate and the issue have to warrant that, as I was saying earlier, based on a cost-benefit analysis. But these disputes, in my experience, tend to be expensive. They tend to be emotional. Somebody who everybody has loved has died and left instruction or not as to how their estate should be distributed. There may be a creditor who feels entitled to a rather large portion in satisfaction of the claim. Those tend to be less emotional disputes, but the disputes amongst the heirs as to their share of the estate, those disputes are highly, highly contentious, typically, and emotional. And think about it. Everybody is kind of playing with their inheritance. It's almost found money sometimes. I think that's the wrong perspective. I think the found money, I'm going to use it to beat my brother or sister or co-heir over the head in a litigation setting because I think I've got more financial leverage than they will. Plus, I've got this inheritance coming to me to use. That kind of thinking generally rewards the lawyers and not the parties, in our experience, because of this judicial discretion that can be used to deny fees or to reduce the fees awarded. Okay, so engaged, seasoned, experienced counsel, get good upfront analysis about whether you've got a good case in terms of fact gathering, the legal issues that will govern, and then applying the facts to the law, understanding that the lawyer is going to be speaking to you based on what can be proven on the admissible evidence, not based on what we know to be true. And there can be a big gap between what can be proven versus what we know to be true. You need to focus on what can be proven and not as much on what you know to be true. Judges will resolve things based on the evidence that proves the position. So be mindful of that. Make sure that you're focused on a cost-benefit analysis throughout the life of the dispute resolution process. And don't forget what I said about attorney's fees. The bottom line rule in the United States, and certainly here in Washington, is there is no automatic award of fees to the prevailing party in a dispute. Instead, the fact finder, the judge, always has the ability in the exercise of their discretion to allow an award or to reduce an award, even to the prevailing party. Okay, so with that, let me ask Sarah, do we have any questions to deal with?
Not as of now.
Okay, well then let's go ahead and wrap up. On behalf of Sarah, Per, and myself, we want to wish you a Merry Christmas. I want to leave open the opportunity if there are questions, either now or based on future viewing. Please feel free to contact any one of the three of us. We'd be happy to discuss in the specific context of your question or situation, how to guide you through. Thank you again. Merry Christmas and Happy New Year.